I am Bill Rochelle, ABI's Editor-at-Large. For this week's installment of Rochelle's Daily Wire Video Edition, I am going to laud a federal district judge who has the capacity, as shown recently, of writing uncommonly fine opinions on difficult questions of bankruptcy law. I refer to District Judge Elizabeth Erny Foote from Shreveport, Louisiana. Bankruptcy law, as you know, is uncommonly beastly difficult, even of course for those who spend their entire lives studying the subject. For a district judge who is handed a bankruptcy problem only perhaps once every few years, bankruptcy law is all the more confusing, difficult, and perplexing. And so, when you find a district judge who is particularly adept at understanding and analyzing bankruptcy law, it really sticks out. And that is, as I said, District Judge Foote in Shreveport. In my column on the 16th of April, I reported a very fine opinion of hers dealing with the question of whether a lessor of personal property in a Chapter 11 case has an administrative claim even if the debtor does not use that property while in Chapter 11. And then, if that were not enough, in my column on June the 1st, I report another decision by Judge Foote dealing with an even more complex, baffling topic. In the later decision of hers, which was filed on the 23rd of May, Judge Foote dealt with the question of 401k plan contributions by a debtor in Chapter 13. And here is the issue. Can a Chapter 13 debtor deduct 401k contributions in the calculation of disposable income? In other words, can creditors, in some fashion, subsidize a debtor's retirement plan and the debtor's higher standard of living after that debtor retires? There are three different answers to that question in the courts, according to Judge Foote's fine decision. And she came down with the answer most favorable to debtors by saying that yes, indeed, debtors in Chapter 13 can deduct their 401k contributions up to the amount allowed by the IRS code. The question she answered was extremely difficult because the case law is all over the place. And the statute, the bankruptcy code, is, as we know, a muddle, in part because of the BAPSIPA amendments in 2005. I would like to also add an editorial comment here, which I think is something that courts should consider, although typically they do not in these decisions on 401k contributions. And here's what it is. Employer-sponsored defined benefit pension plans are disappearing. In another 10 years, they're going to be gone virtually entirely except for some public employees. That leaves debtors, or I should say our population in general, to have 401k plans for their retirement income. It seems to me that Congress, on the one hand, wouldn't give us 401k plans and then take them away on the other with the bankruptcy code. Furthermore, the question strikes me as one whether the effects of bankruptcy should last long after a debtor emerges from Chapter 13 and, in effect, sentence a debtor to a lower standard of living while in retirement as a result of filing bankruptcy. In any event, my hat is off to Judge Foote because she and her clerks have shown uncommon ability to synthesize very difficult bankruptcy law and an opaque statute. I can just imagine the enormous amount of time they spent on their decisions. And so let's say from someone in the bankruptcy community, we appreciate what you do, Judge Foote. In any event, come back same time next week for another discussion of something important in the realm of bankruptcy law on Rochelle's Daily Wire Video Edition.